the debatable issue is, to use a pun, it is debatable. However, I think just about any case can show that there are debatable issues. That's the very purpose that there's a case or controversy in front of the court.
Okay, so let's go. Okay, go ahead. Yeah, go ahead. All right.
But Your Honor, where I think the state truly fails to meet the conjunctive test of RAP 8.1b3 is the preservation of the fruits of the appeal. I think this is undercut by the fact that the state allowed ESSB 5078 to go into effect 3 months after its enactment.
Well,
Now,
okay, all right. All right. I'm gonna stop you right there. Okay, your client, could have easily moved for, to attack that statute right after it was enacted, because that was done. For example, in Guardian Arms and other litigation, as soon as the legislature enacted that assault weapons ban, people were jumping all over that. And there's litigation out there, and your client didn't do that. Okay, instead, your client apparently accumulated like 11,000 LCMs, and was selling them on the market. So this argument that about the delay is I'm finding just a little bit odd, considering what your client's inaction for that period of time until all this came to head. All right, but anyway, you go ahead.
Well, Your Honor, I think it's somewhat of a legal fiction that just any person can jump and challenge a statute. It involves extensive attorney's fees, time, subjecting yourself to the enforcement powers, which are quite awesome, I will say. I nod to my colleagues at the Attorney General's office. They are capable of turning out excellent and voluminous work product very quickly. So I think there's a little bit of a legal fiction that someone can just jump on a challenge to these laws.
Well, the group, Guardian's Arms didn't involve a whole lot of clients, but I understand the point you're making. But go ahead.
And so, Your Honor, I think ultimately the fruits of the appeal, the state cannot carry here. All the state has is speculative harms. They're saying that if the LCMs are allowed to be purchased.
Well, here's something that's not speculative. Okay, here's something that's not speculative: is that the representatives, the legislators, acting as representatives of the people, the elected representative people, enacted this legislation for the purpose of easing people's minds about the danger of a mass shooting happening, where the shooter has, for example, as happened in Las Vegas, has happened in the Aurora theater shooting, that type of thing, has maybe like a 100-round magazine and is going out there and just slaughtering people. And can keep doing it until they have a chance to reload, until they have to reload. Okay, and so I think you would certainly agree that a shooter with a 10-round magazine has got to reload more often than somebody with a 30, a 50, or a 100-round magazine. Is that correct? I mean, they have to pause and reload. Is that correct?
Yes, Your Honor, and I think that's exactly why LCMs facilitate effective self-defense as well. Let's say that Your Honor was in your home at 3 a.m. Some of these crazies who have been calling you recently about this decision are, they show up and they're armed and they're going to knock down your door. I venture to guess that the court would rather have a 30-round magazine than a 7-round magazine.
No, I wouldn't. I wouldn't. I wouldn't. You know what I would do? You know what I would have? Here's what I would have. Okay, if somebody went and knocked down my door, I'd have an M1911A1 like my dad had from World War II, because it's got a nice big round thing, and it'll or a 12-gauge shotgun, which might have 4 or 5 rounds. Come on, I don't buy this idea that you need to have an AR-15 or a Glock or something with 15 or 30 or whatever rounds. I know shooting. I'm familiar with it. So anyway, I don't find that persuasive, but you go ahead.
Thank you, Your Honor. Well,